We're now joined by former U.S. Attorney of Western New York, Joel Violante, who has years of experience prosecuting federal sex trafficking and racketeering cases here in the Western New York District.
All right, the judge ruled detention is mandatory with a Mann Act conviction, and there was no, there was limited exceptions there. Why exactly is he not out on bail, I guess, in layman's terms?
Under the statute in federal court, when you're convicted of certain types of offenses, detention is automatic. The defendant in this particular case was already detained, so it's a heavy burden for their defense to show that, well, Judge, he should be released despite the statute because these are the extraordinary and compelling circumstances that should allow his release and show that he's not a danger to the community, he's not a flight risk, and he'll abide by all the terms and conditions of release. The judge apparently didn't think that the defense has met that burden, which is, as I said, a pretty high burden.
How big of a loss is this for the government? I mean, you're talking about major charges, racketeering, conspiracy. You have prosecuted these at this level, Joel. How big of a loss for them to put this case up and then for them to lose on the three most serious charges? I
don't like to say loss, wins and losses, because it's the system. The jury system spoke. I will say there's disappointments, and I'm sure the prosecution in this particular case is disappointed. They had a lot of witnesses. They had to deal with a lot of victims that said this happened. But it went to the jury, and the jury is a system, and that's what we have to have faith in. And they spoke, and that's the decision that is there. So I'm sure the prosecution's disappointed in it, but he's still convicted of 2 felonies.
We heard last night there were some jury members with unpersuadable views on this case. We know last night that racketeering, they were, that was not decided last night. What happened in the 1 hour this morning when they all got together and deliberated? Because it only took an hour.
I wish I knew. If I did, I'd be hired as a jury consultant. But that's a difficult time. I mean, from the prosecution and the defense, you don't know what's happening because we don't have access to what's happening in the jury room. And you have 12 different people from all different parts of, cross-section community debating about how they see the evidence and view it. And they came back and told the court that, well, we can't reach an agreement. And then at that point in time, the court could have given what's called an Allen charge. My understanding, they gave a partial Allen charge. And the Allen charge is kind of dreaded by some people, especially defense, because some people view that it forces the jury to make a decision. But it's not really the case. It's been tried and tested in the appellate courts, and the court goes through and reads it specifically and says, listen, jury, you're in the best position to decide this case. You've heard it for this many days or weeks or months. No one else is going to do a better job than you are right here. So I'm instructing you to go back and take a look at your viewpoints, take a look at, discuss it amongst the other jurors, apply the law that I give you, and see what happens. It's my understanding in this case they give a partial Allen charge, and the jury went back and listened to the judge and came back.
Is it possible, and one of the reasons we had you here on, Joel, was because of your experience with juries and your interaction with them and, just your history with them. Is there a possibility that, we knew that they were good on 4 of 5 counts last night, and I think everyone that they were seeing in the coverage thought that was 4 guilty counts. That was a big assumption maybe by the public, by the media, by others, when in fact they could have come back with what they did today, which is 2 and then 3 not guilty.
Yeah, you never know, and I was discussing it with my wife yesterday, what's happening, and you just never know.
Yeah.
During the course of these type of trials, the jury will come back, they have questions, they have readbacks, and you're always trying to guess, what does that mean? And I've been wrong so many times. In this particular case, I had a general idea, though. The RICO charge is a really big charge. And when I heard that they were struggling on the RICO charge, but they came to a verdict on some of the other ones, I had a feeling that maybe they were struggling with the RICO charge because when you charge the RICO charge, you're charging somebody a criminal enterprise, and you're saying that this individual ran it, like the John Gotti, essentially, right? And the jury didn't feel that maybe it rose to that level, but they did find that he did some other bad acts, some other criminal acts. They found him guilty of that, but they just didn't believe that he was doing something, in my opinion, under a criminal enterprise umbrella.
What factors now go into sentencing for him?
Well, that's very interesting because he was acquitted of some pretty serious conduct. We all heard on the news, and generally speaking, in federal sentences, acquitted conduct is not relevant for relevant conduct for the court to formulate the actual sentence. In this particular case, he could get up to 10 years, my understanding, maximum, and the judge could take various things in the defendant's background, the acts that he was convicted of, but not the acquitted conduct for determining what the actual sentence is. But but the court also has discretion to use these acquitted conduct in the background of the defendant to fashion a fair and reasonable sentence. So even though we can't say, well, you're acquitted of this type of conduct, if the prosecution presents it and the judge sat through the trial himself and heard this case, and he's in the best position to know whether or not that should be used background information to determine what his ultimate sentence will be.
Wow, so even though he was acquitted of those charges, the fact that they existed in the first place is enough to allow that to be influenced, right? Can it be influenced for the judge?
The court has discretion to consider that by preponderance of evidence to believe that if this is the defendant's background and this is what he's really made of and this is what we think he is as a person, the judge can't consider that type of conduct to say, well, he abuses women or he does this and he does this, and I think these are reasons to give this type of sentence in this particular case.
That's amazing. So the belief is that these sentences will be served concurrently. How does that work as opposed to consecutively?
Well, again, you never know. The court has discretion in that regard. You're going to hear a lot of people talking and speculating whether it's time served or whether it's going to be this much or whether he's going to get the maximum. But at this point in time, it's too premature. The court is going to. The federal courts, all judges I've ever dealt with, they do a fantastic job and want to make sure they get it right. Sentencing is very difficult if you ever talk to a judge because they have to get all this information. You're going to have the probation department do a pretrial service interview of the defendant, look at the background, look at all this information, all the victims in the case if there are any. They're going to be able to submit letters to the court. So the court's going to have to digest all this and fashion a sentence that he thinks fair and reasonable and equitable under circumstances.
Does he get credit for time served?
Yes, he will get credit for his time served.
Interesting.
All right. Thank you so much, Joel, for joining us.
Anytime.
We appreciate it.
Anytime. This
Thank
is
you.
great. Appreciate you.
You're the best person to bring on for something like this.
Exactly.